Welcome to Legalized Negligence. This is a podcast where we talk about Florida's wrongful death statutes, specifically Chapter 768.21, subsection 8, which we hope will be repealed very soon. And my friend Travis is with me today. Sabrina wasn't able to make it. She had a previous engagement. But we want to talk today about all of the Senate and House bills that have been sponsored and filed so far this year, and specifically SB 248, which was sponsored by Senator Yarborough 2 or 3 weeks ago. Maybe, I don't think it's been 4 weeks yet. I think it's about 3 weeks ago. And then within the last few days, Senator Book filed SB442. So we want to talk about those a little bit. About 2 weeks ago, a little over 2 weeks ago, not long after Senator Yarborough filed his bill, I sent him a letter and I outlined some things that Travis and I had talked about with the bill. In fact, we did one podcast already when the bill first came out, and we talked about some things in there that we had concerns about. We were appreciative that the senator was willing to file the bill, and he was trying to address the concerns that he had heard from people, but there were some things that we needed to tighten up. So I sent him a letter and I pointed out four major concerns that we have. And he sent a response back to me that evening. Travis, I'm going to go ahead and share that screen, and then we can sort of walk through that. I hope this is it. Let me know if this is Senator Yarborough's response when it pops up.
It is.
Yeah. Okay. Do you kind of want to go through this a little bit, Travis, as I read along with you?
Sure, absolutely.
Okay. I'm trying to. Okay, the first issue that I mentioned to him was the fact that if we could get into civil court with a medical malpractice claim, we would have 2 years to file that claim. And under Senator Yarborough's bill, SB 248, they had limited that time to 180 days. I mean, we're talking about, 6 months. Is that right? 6 months? Yeah, 6 months versus 2 years. And I had told him, I said, you've given us a quarter of the time to be able to get it. And where that makes a difference is sometimes it can take up to 3 months just to get a private autopsy report back if you have to hire an outside pathologist to do an autopsy. So right there, you've cut your time in half. And if there was any other documentation that you needed, we all know that hospitals do everything they can to slow down sending you the documents that you're requesting. So 180 days was not a great amount of time to deal with this. So Travis, if you want to take it from there, where I think under C he is what the language of his bill spoke about.
Right. Yeah. Okay. If the personal representative of the decedent files a legally sufficient complaint alleging medical negligence by a healthcare practitioner or healthcare facility within 180 days after the decedent's death with the Agency for Healthcare Administration or the Department of Health, and there has not been a dismissal or final resolution to the complaint within 9 months after submission of the complaint, the determination of probable cause is deemed to have been made. What he's explaining here is what follows. While this text appears to limit the personal representative's ability to file a complaint to be within 180 days in order to move forward to court after a hoped-for determination of probable cause, it does not. It states that at the end of the 9-month window, a determination of probable cause is deemed to have automatically been made if a complaint that was filed within 180 days after the decedent's death has not been dismissed or received a final resolution. So this forces the departments, either your ACA or DOH, to finalize their findings. If they don't, then you have an automatic access to the civil court.
Right. But he still doesn't address the 180-day issue. We're still cut down to 6 months versus 24 months.
Right. What he's saying is if we miss that 180-day period, then you miss the benefit of having this automatic access to court.
Yeah.
I'll continue reading. A personal representative could still file a complaint beyond the 180 days, but the mandated determination of probable cause due to no dismissal or resolution within 9 months requirement would not apply. Albeit seemingly slight, there would be an advantage for personal representatives to file within 180 days, but that is not a capped time period for the filing of a complaint. All of that said, I believe the text in question needs clarification in order to avoid sending the wrong message and confusion, so I am working on that.
So right there, he's willing to admit that he needs to tighten up that language a bit, that he recognizes the confusion in that language. In the next part, and all of, the truth of the matter is all of this will be moot if we can get Senator Book's bill to be heard, because she doesn't have all of these caveats in hers. Hers is just simply strike subsection 8 and be done with it.
Mm-hmm. Yeah, the biggest problem I see with just having the 180-day limit is you have to establish probate, you have to have the letters of administration. That gets delayed if you have out-of-state heirs involved because of mailing and such. You have to have the findings. You have to do your HIPAA reports and have them respond without doing an extension. Then you have to go through it, find fault or what you believe to be fault, and then file within 180 days. I know that is very easy to miss. And I know that while if you get your complaint in within 180 days, you could have a very easy ticket to the court, because I got a letter from ACA saying that they'll take 3 years to investigate a claim that I had. I'd have an automatic ticket. But still, you have to discover and be able to file within 180 days. And I just don't think that that's fair at all. To lose your benefit.
And there's another part in there where you just mentioned the discovery. My mom's medical record was 1,600 pages long. You don't go through that in an evening. It took me almost 2 months to get the hospital to send it to me. And it took me another 6 months to review the entire thing. That's a lot of work. And if you're a person like me that didn't have the money to hire a medical expert to go through it, you're kind of up the creek. So
yeah, you're doing this all on your own, because while it does allow for damages, economic and non-economic, that doesn't come into play yet until you get access to the court. So you're still doing this without an attorney, and even possibly an expert witness, because they typically won't get involved unless there's an attorney involved.
Correct.
That's what I found. So, and then you got to learn medical, issues and legal issues within 180 days. So it's not practical.
Yeah, it's not, but you're exactly right. It's not practical at all. The next part that he talked about here was the level of fault. Let me see the next point. Let me just read this. The next point speaks to the level of fault. I will not argue with your assessment of this. While I understand an outright appeal of subsection 8 is preferred, multiple attempts to do that over the last several legislative sessions have been unsuccessful. This is why I filed SB248 as an alternative to at least try to create a path where none exists today. If it were to pass, it would not hinder the ability for interested parties to continue pushing for an outright repeal. So, he recognizes that what we pointed out to him, is valid. If you want to take that third point, Travis.
Okay. The third point relates to laws passed by the legislature and rules slash policies that could be put in place by departments, agencies, etc. I fully understand the concern about the time frame, but if the legislature mandates a duration in law, as is the case with SB 248's 180-day and 9-month periods, DOH and ACA would be breaking the law if either or both were to impose a stricter standard. If the legislature did not give specific timeframes, they would likely be within the bounds to adopt limits. But in light of the current bill's provisions, they would be violating the law if they did not abide by the durations that are specified.
Yeah, what I had said to him there in my email to him was that since it's an administrative agency, ACA and DOH, they write their own policies. So even though the legislature said 180 days, if these administrative agencies decided to change that at some point, they could. And he's telling me here that they can't if it's written into law, that it will remain at 180 days, or DOH or ACA will be breaking the law.
Okay, here's a caveat that Paul Reinhardt had mentioned to me, is because it's an administrative process against the licensee, they would have an appeals right. So let's say at 180 days, you get your verdict and it's a beneficial one to you, detrimental to the licensee. Well, now they get an appeal process. Does that hold you up still going into civil court?
Well, the 180 days, I think you meant to say 9 months there. You have 180 days to file your complaint, but if by 9 months, and let's say it was 8 months and 29 days, the defendant or the respondent appealed it, then what does that do with you,
Right.
at that point?
Is it an automatic stay of your progression into court or what?
Yeah, again, that's probably more language that he needs to clarify. Do you want to take that final point there, Travis?
Okay, the final point about the application of the provisions of Senate Bill 248, and I understand where you are coming from on this also, which is why lines 53 through 57 are included. The decedent's personal representative may initiate a medical negligence action to recover the damages described in subsection 3 for the adult children of the decedent, or the damages described in subsection 4 for each parent of the decedent, also as provided in this subsection. This text clarifies that what we are doing only applies to the same groups that are affected by current statute 768.21 subsection 8 versus all wrongful death claims.
Yeah, now where that came from was my question to him in my email was, it sounds to me like you're now placing every medical malpractice claim has to go through the Department of Health or ACA, even the people who don't fall under subsection 8. And what he's saying here is that no, it doesn't affect those. It only affects those people who currently fall under subsection 8. Is that how you understand that?
That is correct.
Okay.
So we still have a carve out.
Exactly. We still have a carve out. So I'm going to stop sharing that screen at the moment, Travis, so we can talk a little bit more about this before we get into Senator Book's bill. Overall, I appreciate Senator Yarborough trying to do something. It was obvious to me that he was listening to constituents and he's recognized that there was problems. And I think he just made it a little too complicated. He put in all these caveats. And Travis brought up a very good point while we were talking yesterday morning. There was a case back in 1896. I've referenced it in a number of things that I've written over the last few months. It was called Plessy v. Ferguson. And the case went before the U.S. Supreme Court. It was after the Civil War, and people in the South were still finding ways around the fact that blacks had been given citizenship and they wanted the same rights that white people had. So what they were doing was, we'll take, for instance, and the case was about train cars. Blacks were now allowed to ride on in a train car, but they gave them a separate train car to ride in. And the train car wasn't as nice and it didn't have the same amenities as the train cars that the white people could ride in. So a case came along and it made it to the Supreme Court. And astonishingly to us in 2023, the Supreme Court ruled that that's fine. They didn't rule, they issued an opinion that that's fine. You can have separate but equal. And most of us have heard that term, separate but equal. Well, that was eventually overturned 58 years later in a case in 1954 called Brown versus Board of Education. And actually, there were several cases mixed in there, but all Brown versus Board. But they finally overturned Plessy and said that no, you can't have separate but equal. That's not equal when it's separate like that. And Travis brought up a great point yesterday about Senator Yarborough's bill, is that basically he's doing the same thing with his bill. He's trying to give us equality of everybody else, but he has separated us in such a way that it's not really equal. If we can't access the civil courts the same way that anyone else can access the civil courts without having to take this little side trip over here to the Department of Health and ACA, then it's not equality. It's Plessy v. Ferguson is what it is. It's separate. So I'm hoping to make that point to him. I'm going to be writing him a letter here in the next day or two, and I hope to make that point to him. Travis, before we move to Senator Book's bill, do you have anything else you want to say about Yarborough?
If you look at the bill text on like line 94 starting, if the personal representative of the decedent files a legally sufficient complaint, it mandates that you have a personal representative there. I'm not sure if it mandates it, but I'm concerned that those that have done their estate to where they have trust and such to stay out of probate, they may not need that. My window went away. Let me see. That was one question I had. I'm not positive.
Yeah, I just pulled up his actual bill so you can see line 95. Is it big enough to see it?
Let me make it large again here. 95. Your highlighting is a little bit different than mine here. Okay. Yes, you had discussed this and tried to clarify with me where, you believe the heirs, the kins could bring their own action, and this was specific to the personal representative. This is just where I kind of got hung up on. If you scroll up to line 40, the other issue I had, let me see, 40. Okay. Or 39, I'll start reading. The medical expenses described in this paragraph includes amounts paid by the decedent or the decedent's estate. That rules out any payments that might be paid on behalf of the estate that the estate would like to recoup and then pay those generous persons back. I would just like to see where it says paid on behalf of the estate as opposed to paid by the estate. But ultimately, this bill, I think we agree is really been replaced by another Senate bill, 442. That really we need to take a look at.
Yeah, and one more thought on I'm pulling up 442. One more thought on having to have an estate set up. It took about 2 months for us to get an estate set up for my mom. Now, granted, part of that was because of COVID. My mom died in May of 2020, and COVID was still a very new thing, and the courts were trying to get everything e-filed because nobody was actually going to the courts. And part of it was because of COVID, but it took about 2 months for that to happen. Well, you've just eaten 60 days out of your 180 days just to get somebody who has the legal authority to request documents. So again, that points to what you were saying before. It's not practical to do that. You know, that 180 days simply is not long enough.
Well, it also doesn't consider the economic situations of various families, because here they are, they're having to come up with funeral expenses, burial expenses, all this other stuff, and now they have to hire an attorney just to go through this process. You know, why create that burden? I don't understand why.
Yeah, I agree. Do you want me to share this screen of Senator Book's bill, or do you have yours that you have highlighted and want to see that?
No, I haven't highlighted this bill just because it's a perfect bill.
Okay.
Go ahead and share it. They're mirrored. There's no reason to have separate, you know.
Okay. Is that her bill 442?
442, yes. You want to zoom in and make it wide?
Okay.
Want to widen it?
Oh, you want me to widen it?
Yeah, zoom in just so that people on the video can see it wider. Scroll, control scroll. Yeah.
Okay, tell me where you want me to go.
Well, line 13, I guess, starts the actual bill. This is pretty much a mirror image of the House Bill 129, which, you know, you need to have the same language in both the House and the Senate.
Right. And then, like you say, we can go through this pretty quick and for people who've never read bills that are being submitted, anytime that you see strike through on any language, that means that gets taken out. Anytime the language, there's nothing done to it, like strike through or underline, that means that's the current language. Senator Book has gone down here on line 20 and she struck out anything that had to do with 768.21 subsection 8. And the same thing all the way down until we get to the bottom. Basically all she's done is says that these exceptions do not apply. These exceptions, which 768.21 subsection 8 created, they don't apply anymore. And then you get down here to the actual subsection 8 on line 55, and she just strikes the whole thing, which is what Representative Lopez did in her bill, HB129. Just get rid of it. That's what we've been asking for all along. Just take it out and be done with it.
It's perfect because it doesn't throw us into an administrative chaos of the Department of Health or Agency for Healthcare Administration. No hoops to jump through, no having to start probate and such. It's the same rights and privileges that every other citizen or visitor of Florida has, and it makes us equal.
Yeah. And people need to keep in mind that if you can get into civil court, that doesn't mean that the jury in that civil court is going to be able to do anything to the doctor's license. That is still going to have to be done through the administrative agency of the Department of Health. But getting into the civil court would allow us to be able to recover the same damages that any other tort claim in the state has the ability to recover. And I mean, that's what we've been asking for all along. The other issue is that Danny Burgess, Senator Danny Burgess, said in an interview a couple of years ago that it would just open up a Pandora's box of lawsuits if they did away with subsection 8. Well, I disagree with that, and I know you do too, Travis.
He said May.
Yeah,
May.
he said May, but you and I both disagree with that, and here's why. I think it's in chapter 766, where they talk about pre-suit requirements in order to file a medical malpractice claim. And it says the intent of the legislature in writing these pre-suit requirements was to weed out the frivolous lawsuits. So if they're concerned about too many frivolous lawsuits, there's no reason that the same pre-suit requirements can't apply to us just like they do everyone else. So take somebody who survives a medical malpractice incident. They have these requirements that they have to go through, which are I think they have, remind me, is it 90 days? And then, and they
Yeah,
have,
there's a tolling of time, tolling of the statute of limitations for 90 days for the purpose of the pre-suit once you give notice.
right. And oh, that's what it was. You have to give notice 90 days before you ever file your suit. In other words, you're putting the other party on notice that you're going to be filing a suit in the future. And the reason that they set up that time period was so that the other side and your side can get medical experts to sit down and come to a decision on whether or not this is truly malpractice or if it's just the family doesn't understand exactly what happened. And I really don't have a problem with that. It does weed out the frivolous suits. But that's all we're asking is let us do the same thing that everybody else is doing. So it takes care of the problem that they said too many frivolous suits. So we deal with that. There's just no reason to send it to the Department of Health or ACA and put us through all of that nonsense when the pre-suit requirements will accomplish the same thing.
Yeah. And if anything, it leaves a lot of the law that's been put in place to protect the people from being effective, such as the 3 strikes law or rule. Preventing people that have fallen due to subsection 8, it prevents those cases from creating a strike. And so only people that aren't injured enough that they're able to survive, only those cases can cause a strike. And even though not all those cases will, because you can have a pre-suit settlement and those cases don't cause a strike. So this really is a protection for the people. And it's just fair protection.
Yeah, and that's what the whole thing is supposed to be about. The Department of Health licenses these doctors and nurses, and they're supposed to look over their shoulder if they, and see if they're doing anything wrong. And the whole purpose of it is to provide safe health care to the people of Florida and anybody who visits Florida. So, it's their obligation to do that. That you would think that they would want people to let them know when a doctor has done something wrong and then look into it and determine whether he did or not. There's all kinds of allegations about things in every walk of life, but it certainly needs to be looked into. The point is you want to weed out the bad doctors. And like you and I have been saying since the summer, when we read the task force report from 1988, 4% of doctors cause 42% of malpractice payouts. And, Travis made the comparison. Imagine having 100 employees at your business and 4 of them cause 42% of your profit losses. That's what it works out to. Or a police department with 100 police officers and 4 of them are the ones that are causing 42% of the lawsuits against police for inappropriate conduct.
Yeah, it's ridiculous.
Yeah.
To not allow the access to the court to allow the people to enact the laws that are there to protect us.
Well, that's a good place to bring up. There was a book I read there it is, a couple of months ago, and
Hmm.
Travis has a copy of it. If you're interested, you can find this book online. I found it at Amazon. It's called The Medical Malpractice Myth, and it's by an attorney named Tom Baker. And he drew his knowledge from some studies that started back in the mid 1970s in California, North Carolina, Texas, Florida was part of it. And he shows very clearly how uh, insurance companies have a roughly 7-year cycle that they go through of what he calls boom or bust. And when it's bust, it's they have not set aside enough money uh, to pay for any malpractice claims that come up. It's not that suddenly there is an increase in medical malpractice claims. It's a miscalculation on the part of the insurance companies where they just didn't set enough aside enough money. Kind of like if you don't set enough aside enough money for your property taxes, you're going to have a really big bill at the end of the year. Where if you set aside a little each month, it's not going to hit you as hard. And the whole crisis is caused by a miscalculation in the insurance industry. And then they try to turn it around and dump it in our laps and make it like it's our fault.
Right.
So anybody who's interested in reading about that, that's one good book. And there's several of them out there, but that's a really good one that we've recently read and got a lot of information from. Well, Travis, do you think there's anything else we need to discuss?
Uh, no, we pretty much hit all the bases. Just the two bills that are in the forefront, in our opinions, is Senate Bill 442 and House Bill 129. Those are the perfect, ideal, clean, clean solution to the problem.
Yeah, and I guess if you're going to, make any phone calls or write any letters, I would suggest writing to Senator Book and Representative Lopez and thank them. They're the two that have come up with the exact bill that we've been looking for. Um, you might want to write to Senator Yarborough and suggest that he, pay attention to Senator Book's bill because she has just handed us what we've been asking for all these years. And of course, they're going to say that if we go with Senator Book's bill, then there's got to be caps on any damages, but that's a whole different legal battle there.
Yeah, the biggest thing right now, I guess, would be, Yarborough's position is he has to allow Senate Bill 442 to be heard and voted upon.
Yeah. So
And with him having his own bill, we know that the natural inclination is to have your own bill there, but hopefully he'll allow it to be heard.
yeah, well, I think this is an excellent example of Occam's razor.
Hmm.
The simplest solution, Senator Book's bill, is usually the right answer.
Yep.
Hers just strikes the subsection 8 and gets it back to where it was before 1990. And one last comment I would like to make, and we all really need to start working together on this stuff. If we don't present ourselves, all of those of us who fall into the subsection 8 category, if we don't present ourselves as an organized front, all trying to do the same thing in a civil manner, and we're going to lose this thing. We're coming down to the line on this. They're already hearing these bills in various committees. They're going to start voting on them beginning in January on the 9th when they go back into session. And the last thing we want to do is present ourselves as a bunch of people who can't even agree with each other. There's no need for name calling, for backbiting, for, fighting with somebody just because you disagree with the way they understand it. If you think they need to understand it differently, then take some time and explain it to them and help persuade them to see it your way. Don't attack them. We're all on the same side here, and we need to start acting like it. And I'll just leave it at that. Travis, unless you got something else.
No, just education. Learn.
Yeah.
Mm.
Well, thank you for your time, Travis, and hang on after I stop this recording and we'll chat for a minute. I forgot to give our disclaimer. Um, neither one of us are attorneys. We're just a couple of geeks who like to read a lot, and we enjoy reading about medicine and law. And our common interest is that we both lost our mothers to medical malpractice, and we're seeking justice for that. So don't take anything we say as legal advice. Go out there and do your own research and see if you come up with the same answers that we have. And join us on our Facebook page at Legalized Negligence and on our YouTube channel at Legalized Negligence, and stay up to date with all of this information. Everybody have a good day.